Good evening to our European participants and a good afternoon to colleagues joining us from the US. Our presentation today is targeted at an informed user level and will therefore focus on what we believe are the key issues to be considered during EPO prosecution. We plan to chat for around 30 minutes, after which we'll open the floor for a Q&A session. Next slide, please. In the US, of course, it's a question of non-obviousness, whereas in the EPO, it's a question of inventive step. The mindsets are slightly different. Non-obviousness flows from asserting a negative, whereas inventive step requires demonstration of a positive. So for the EPO, I would encourage you to think in terms of a two-step process. The first step being how to establish inventive step. This has to flow from an unexpected technical effect and must convey an improved property across the scope of the claim. It's only after this step has been addressed that one can then move on to a discussion about claim scope and what type of data will likely be required to support such a claim. I'll now hand over to Hazel.
Thanks, Martin, and hello, everybody. I'm going to start off with some good news. It's still possible to get a broad antibody claim at the EPO if you have a new target or a new use for your antibody. So, for example, if you find a new target which people wouldn't have or couldn't have made antibodies against in the past, then you may be able to get a broad claim at the EPO covering any antibody against that target. There is no written description requirement at the EPO, so there's no formal requirement to disclose individual species of antibody across the scope of the claim. If your antibody is based on a new epitope, then you would need to define that epitope clearly in the claim, and you would also need to make sure that your application contains enough information to enable the production and identification of antibodies that bind to that epitope. This can sometimes be more challenging if we're dealing with a complex three-dimensional epitope. Where things get more difficult is when the target of your antibody is known, and I'm going to hand back to Martin now to talk a bit about that.
So reliance on either a new target or a new therapeutic indication can often be something of a luxury. So what happens when one's antibody target is a known antigen? How can I establish inventive step? Well, in short, there are two options. Either one must demonstrate an unexpected technical effect, or one must demonstrate hitherto manufacture problems have been the rate-limiting step. In short, it's just not good enough simply to shout that my antibody sequence is different.
So an important point to understand is that the EPO views a lot of things in the antibody field as being routine and straightforward. The EPO takes a default position that it's routine to produce antibodies against a given target and also to make some types of improved antibodies, such as by humanizing them. If your antibody has been found or could have been found using these types of techniques, then you will be starting on the back foot in EPO prosecution. So, for example, the EPO takes the view that given a target of interest, routine methods could be used to produce a large panel of antibodies against that target and to screen them to pick out the best antibodies that bind to that target. That type of reasoning can be helpful when it comes to establishing that you have enablement across your scope of your claims. But as we will see, it is often an issue when we come to consider inventive step in Europe. Where things get particularly difficult for inventive step is that the EPO then extrapolates from that logic and reaches a conclusion that prima facie, by just using these routine methods and trial and error, any antibody against that target would have been found eventually by this kind of routine immunization and screening. So we've got a few examples from the case law in these slides to illustrate how the EPO deals with some of these issues. And this slide gives a quote from an EPO Board of Appeal. Here, there was a new antibody that had been produced against a known target, CXCR4. The Board of Appeal noted that the skilled person would have known how to produce antibodies and that they would have been generally motivated to produce antibodies against this target. Their conclusion is set out in blue, and the quote, they concluded that all such antibodies against the target would have been obvious to the skilled person, with the claimed antibody just being one of many potential antibodies that could have been produced, with each of those potential antibodies being considered obvious. So prima facie, according to the EPO, it is if it's obvious to make antibodies against a particular target, then all antibodies against that target would also be obvious. As Martin said, it doesn't matter if your antibody is new and if it has a different sequence, such as different CDRs, compared to prior art antibodies against the same target. Structural non-obviousness does not work as an argument in these cases at the EPO. So I'll hand back to Martin to talk about how we can deal with this kind of problem.
So what type of unexpected technical effects can we rely on? Well, rather than reading the list, I'll simply refer you to the slide which lists some of the more frequently relied on technical effects. There should be no surprises. The simple answer is yes. Some advantages are clearly better than others. Advantages will typically fall into one of two categories. A predictable advantage may well be problematic, as this will inevitably involve some form of quantitative assessment and argument, ultimately begging the question, the obvious question, no pun intended, what is the threshold? On the other hand, an unpredictable advantage should be much more reliable, and this will typically involve only a qualitative type assessment and argument. And to repeat earlier comments, unless an inventive step can be established, any type of claim will likely prove problematic, even a picture claim.
And so this is another example of an EPO case that actually illustrates a few of these points that we've been talking about. In this case, the original claim, which is set out in bold at the top of the slide, defined the antibody functionally based on having a particular level of binding affinity. The EPO considered that this wasn't a surprising advantage over the prior art. The opponents in this case had argued that this was, in fact, just the level of affinity that you would have wanted to achieve if you were looking for a therapeutic antibody, and the EPO decided that the claim lacked an inventive step because antibodies having that binding affinity would have been found in an obvious way. So the patentee amended the claim. They amended the claim to add a specific epitope sequence into the claim. The EPO said that that amendment didn't fix the problem because there was still no evidence that the antibodies that bound to that epitope gave any unexpected advantage over the prior art. So the patentee then tried a different amendment. Instead of specifying the epitope, they introduced sequences from their preferred antibody into the claim. In this case, they added the variable domain sequences from their antibody into the claim. The EPO still found that the claim lacked an inventive step. This emphasizes the point that Martin just made, that if there was no unexpected advantage associated with the antibody, then it didn't matter how narrowly that antibody was defined in the claims, it still wasn't considered to be inventive. Eventually, in this case, the patentee did find an allowable claim, but only by limiting the claim to a particular use of the antibody where the inventive step was based on that use rather than based on the antibody itself. Based on the new use, the EPO allowed a claim that actually had the original broad antibody definition, referring only to the affinity of the antibody to CGRP, but limited by the use of that antibody to prevent or treat headache. So in this case, they weren't able to get a claim to the antibody itself, even by coming down to specific sequences from that antibody, because the EPO thought that there was no surprising advantage related to using that particular antibody, but they were able to get a broad antibody definition in their final claim by covering only one particular use of that antibody.
So in terms of technical effect relied on, this must be credible across the entire scope of the claim in question. To the extent this is brought into question, however, then a more specific effect may need to be relied on, giving rise to a less ambitious patent claim in terms of claim scope. The EPO applies a somewhat reassuringly logical approach in terms of which parts of an antibody are required to be recited in a claim. These structural features being linked to the underlying technical effect asserted by applicants. The next slide, please. This slide illustrates the principal structural features, which we'll all be very familiar with, of an antibody. And Hazel will now briefly describe how the EPO applies its logical thought process to the types of technical effects that are relied on and what is then required in a claim to support that feature.
So, as Martin has said, the scope of claim that the EPO might let you have will depend on the nature of the advantage that you are relying on to get inventive step. If we look first at a scenario where your advantage relates to the specificity of binding of your antibody, so it might, for example, be selectivity for binding one antigen but not binding other similar antigens, then the EPO generally acknowledges that binding specificity of an antibody is a property of the CDRs. So in this kind of situation, where this is the type of advantage that you're relying on for inventive step, the EPO may allow a claim where the antibody is defined by the CDR sequences. The EPO does generally assume that binding specificity requires the presence of all 6 CDRs. So as a default, they would want you to recite all 6 CDR sequences in the claim. It might sometimes be possible to get a claim that has a broader scope. So, for example, allows you to have fewer than 6 CDRs, or that allows for some sequence variation within the CDR sequences. But to get that type of broader claim that doesn't require all 6 CDRs, you would probably need to have some supporting data to help you persuade an EPO examiner that the advantage that you're relying on, for example, selectivity of binding, would actually be achievable using those types of sequence variants. One of the most common advantages that is relied on for inventive step is that your claimed antibody has an improved affinity for its target. The level of affinity that would make your antibody inventive is going to depend on the particular facts in your case and what the examiner considers the skilled person might reasonably expect to achieve. It may also depend on whether the affinity of any prior art antibodies was already known, so that you can demonstrate an improvement over those. If you are in this situation where you're relying on improved affinity to get an inventive step, then the EPO takes the view that binding affinity of an antibody is not just a property of the CDRs, but that the framework regions can also have a considerable effect on the affinity of the antibody. If you're relying on achieving a particularly high affinity to get your inventive step, then I would expect the EPO to ask you to include the sequences of those framework regions as well as the sequences of the CDRs in the claim. So your claim will probably need to recite the full heavy and light chain variable domain sequences of your antibody. Again, it may be possible to get a broader scope of claim in some cases, but to do that, you're going to have to persuade the examiner that you don't need to include the full variable domain sequences. So, for example, with evidence that other sequences would also have the improved affinity, or that particular fragments would have the same affinity.
Here are some of the less frequently relied on technical effects. And when relying on any of these effects, it should be remembered that the burden is on applicant to demonstrate the effect across the scope of the claim. This has to be credible. In order to make it credible, there's a need to be able to link an effect to structural features or a combination of structural features. And in the absence of that link, the EPO will take a default position that the claimed effect is simply a property of the entire antibody, which requires the complete antibody sequence or sequences to be recited. Back to Hazel.
So here we have another example from the case law. This is actually a case from the UK courts rather than from the EPO, but it illustrates the same basic principles that we've been talking about. In this case, the patentee argued that they had found an improved effect of reduced ADCC, and they argued that this could be achieved by increasing the fucosylation of antibodies, even if those antibodies were used at high concentrations. The court looked at the data in the case, and they agreed that the data made it plausible that this advantage had been shown for the exemplified antibody and at the concentration that it had been tested at, but it was found that it wasn't plausible from the data that were available that this effect could be extrapolated to other different antibodies or even to higher concentrations of that same exemplified antibody. As set out at the bottom of this slide, the judgment set out a variety of questions to be considered when an advantage was being relied on to give an inventive step over the prior art. First, the questions consider whether an advantage has actually been achieved compared to the prior art, then whether that advantage is surprising and so inventive, and then the final question is whether that advantage supports claims of this breadth, so whether that advantage will be seen across the full scope of the claims. These issues will be assessed based on the facts of each particular case, and you should expect, both from the EPO as well as here in this UK court decision, that the analysis will be quite technical and scientific. So I'm going to hand back to Martin now to talk about the type of experimental data that might be useful to support inventive step arguments.
So the technical effects relied on must be plausible based on the data presented in the specification. In practice, however, this is actually a fairly low threshold. That said, it's important to think ahead and to consider what type of possibly more refined technical effect fallback positions might be required should one's principal technical effect fail EPO scrutiny. Next slide, please. For example, when considering, say, a therapy claim, clinical trials data are not essential. Indeed, very basic in vitro binding or neutralization data may well suffice, and non-human data of any type will often be more helpful than not. Where prior art similar antibodies are known, comparative data can indeed be most helpful, though again it's not essential. The problem, of course, with trying to compare with prior art antibodies in different experiments, then you're at the mercy of like-for-like comparison tests. Where a claim is designed, for example, without framework region features, then a range of examples illustrating inner framework mutants would be considered helpful. It would just help support the general concept that's been presented there. Back to Hazel.
So sometimes it's helpful to be able to file more data during prosecution that wasn't available when the application was filed, or in fact data that you just didn't realize you needed when the application was first drafted. So for example, if at the time your application was filed you had some preliminary data You might want to file more data during prosecution to confirm or build on those results. For example, filing in vivo data that confirms the effects that were suggested by earlier in vitro experiments. As Martin's mentioned, comparative data can also be useful. It can be particularly useful as post-filing evidence if you are trying to establish that you have an advantage over particular antibodies that are in the prior art. It might be useful to be able to file a direct comparison between your antibody and a particular prior art antibody that the examiner has focused on to show that your antibody is better. Or you may just want to file data where your antibody has been tested using particular methods that were used in the prior art, again, to support an advantage for your antibody over antibodies that are in the prior art. It is possible to rely on these types of post-filing data at the EPO to support an inventive step, but the EPO will only consider post-filing data if those new data support an effect that was at least plausible based on the information that was in the application as originally filed. The effect that the inventive step is based on must be derivable from the application as filed. So again, here's another EPO case. In this case, the applicant argued that their antibodies had an unexpected ability to induce immunotolerant T cells. The Board of Appeal looked at the information that was included in the application as originally filed, and they noted that this particular effect wasn't specifically mentioned anywhere in the original application, and they said that it wasn't supported by any of the data in the examples, which didn't point particularly to this mechanism of action. Even when they took into account the common general knowledge when reviewing the information in the original application, they found that you would not have inferred that this advantage might exist. So the board concluded that the effect that the applicant wanted to rely on wasn't something that was derivable from the application. In the absence of anything in the application pointing towards that effect and making it technically plausible that that effect might be achieved, the EPO would not allow the applicant to rely on that advantage to give them an inventive step. So if you can find an advantage for your antibody, then that's great, but you need to be able to tie it to something that was in the original application, particularly if you are going to need to rely on post-filing data to support the fact that that advantage exists.
So, in conclusion, I'd encourage you to think about this two-step approach in the EPO. It's first necessary to demonstrate the inventive step, and then as a second tier to go on to discuss the claim scope. It's necessary to disclose the effect, and that's both for written description purposes and to establish the plausibility of that effect. Generally, the plausibility will require some basic data. Try to think ahead of the technical effects that one might wish to rely on should the principal technical effect fail, because for those subsequent technical effects, one will also require the written support and the plausibility data. If there's one take-home message, it is the burden's on applicant to demonstrate what the EPO won't otherwise accept. I'll now hand back to Saba for Q&A.
Thank you, Hazel and Martin, for your presentation. It is now time for the Q&A, and I think we have a couple in the midst. Hazel and Martin will try and answer all your questions, but if we don't cover them today, then we'll follow up with you separately. Back to you, Hazel and Martin.
Okay, so we have one question, which is, how does this work for bispecific antibodies? So I can go first on that. The basic answer is that the same principles that we've talked about will apply for any kind of antibody type claim. The EPO will look at the particular type of antibody that you're claiming, and they will be looking at what was well known and routine about those types of antibodies at the time your application was filed. So if you're looking at a bispecific antibody and it was known that combining together two different antigen binding regions in a bispecific antibody of that type was expected to impede the affinity of those antibodies, for example, then you might be able to show an advantage by retaining the original affinity from the two parent antibodies. Whereas if it was known at the time your application was filed that you should be able to retain the original affinity even though you've combined them together in a bispecific antibody, then at that point you would need something more than that to establish an inventive advantage.
I can see we have one new question there, which is what will likely happen when there are multiple antibodies? Which will the examiner usually pick? In my experience, the examiner will pick the one that is the closest technical match. So the technical field is the most important. Hazel, would you like to add anything to that?
Yeah, I think the examiner will tend to look at what your application says you're going to use it for. So it's not necessarily going to be the structurally closest antibody. It's probably going to be the antibody with the closest use, or antibodies that clearly bind to the same target.
There's one further question there, which is to what extent can one rely on functional wording to negate the need for precise structural recitation? Hazel, I think that one's right up your street.
You can certainly get antibody claims with functional features in them at the EPO. I think it depends a lot what the functional feature is as to how likely it is you'll be able to get that through under EPO practice. If you're relying on functional rather than sequence features to define your antibody, then you are more likely to encounter problems at the EPO relating to clarity and sufficiency. So one classic example of the EPO is what they call result to be achieved, which is where the examiner thinks that your functional feature is just essentially a description of what you'd like your antibody to be able to do. And the EPO really doesn't like that kind of functional definition in the claims. And generally, if there is a way that you can define your antibody structurally based on sequences, for example, CDRs, then probably the EPO is going to ask you to do that. Having said that, it is still possible to get these claims, and what's possibly more common is to have a combination of structural and functional features in the same claim. So you might specify the 6 CDRs and then also have some functional definition as well that would be combined with that together. And I think that tends to go down a bit better at the EPO. You got anything else on that, Martin?
No, I think I would always be very wary of functional language, particularly where there's an element of a clarity issue around that. And of course, clarity is not a ground for post-grant issues, but a broad interpretation of an unclear term can lead to unfortunate and novelty anticipations, and then trying to address that in a post-grant scenario can be sometimes very problematic. We have another question here, which is, do you see differences in interpretation and/or importance of any of the points mentioned for antibody claims in diagnostic patents as opposed to therapeutic antibodies? I think the main distinction there for me is the technical effect that's relied on. There will be fewer technical effects that will be relevant to a diagnostic claim than there would be for a therapy claim. So there'll be a much higher pressure on things like specificity and well, specifically diagnostic-related indications. Hazel, anything to add?
No, I don't think I have anything on that. I'll pick another question. We've got a question of whether a description in the specification would be sufficient for plausibility, even if there are no experiments included. And I guess the answer to that is yes, in principle, as long as what you have described in your specification does actually make it plausible that it's going to work. So if you've got a technical explanation for why you would get an effect, and that is, scientifically credible that would work, then that is quite often enough. You don't necessarily have to have experimental data. It may be that your experimental data aren't quite on point for the effect that you're talking about, but that you've got enough information that if you combine it with other information in the common general knowledge, then that makes it plausible that you would get that effect. So you don't necessarily need to include direct supporting data, but you need to have some kind of scientific rationale for coming to that conclusion based on the information that you do have.
Yeah, I think the flip side to that is the tougher your inventive step argument becomes, if the more you have to rely on something that's already in the prior art.
Yeah, absolutely.
Another question here that's specific to affinity. So there's a question, there are recently rejections that obtaining increased affinity is also routine. I think increased affinity is actually one of the things we talked about. And the presumption there is that it's generally routine to obtain antibodies with improved affinity. It's this quantitative rather than qualitative issue that I tried to refer to. Hazel, would you like to add?
Yeah, I mean, I have had objections from EPO examiners. I think there are perhaps some EPO examiners that raise that objection. And the approach that they've taken is that if you are producing antibodies by immunizing an animal, then the obvious thing to do is when you're screening a panel of antibodies to pick out the ones with the best affinity. And so that tends to be the logic they're using. I would say that if your advantage is something other than affinity, it may be easier to establish. But again, yeah, you need a particularly good affinity to have a really convincing argument at the EPO.
Another question, will including epitope information in the application facilitate an inventive step argument for sequence-based CDR claims? That's an interesting one. I think it certainly sets up a nice argument, but I think the credibility of that argument will then come down to whether the data actually map onto it. So you would need some supporting data around how specific the epitope is. So what happens when you change the epitope slightly? Do you see a marked effect or do you not? Yeah, I think that's a good one. Hazel?
Yeah, no, I agree with that. We've got another question here of whether you can claim consensus sequences of CDRs if only one set of CDR sequences support inventive step. I would say if you've only got data with one set of CDR sequences showing your advantage, then that is what the EPO wants you to claim. If you want to claim a consensus sequence based around that, I think you are almost certainly going to need some more experimental data to persuade the examiner that related CDR sequences, for example, would also have the same effect. I think at the moment the EPO is probably going to assume that a single set of CDR sequences is all you will get without some particular reason to expand those sequences out.
There's a question I missed earlier, which is where there are multiple prior art antibodies, will the examiner usually pick one? And then related to that, where you identify certain prior art antibodies in the application, will that give a hint to the examiner to pick one? That's a nice leading question. I would certainly be minded to do exactly that and to try to encourage the the examiner to look at the right antibody, and that may well help you through the first phase and get you through prosecution. Of course, once you're in a contentious area under opposition, then the question resets, and there would be a much broader assessment of which is the correct antibody, because of course all those other antibodies that aren't identified in your specification will be brought to light by an opponent, and then the opposition division would be faced with making that objective decision.
We have another question here. I don't think we've covered it. I'm losing track. Can you have a granted patent on an antibody comprising a sequence ID for binding to a target, but with no information regarding the epitope? I think you can, as long as the target is identified. I don't think you need to give a specific epitope for your antibody. You don't need to define exactly where in a particular antigen the antibody binds. I think you probably do need to say what protein or what structure is bound by that antibody. But again, as long as you have some advantage achieved by using that antibody, you don't necessarily have to have drilled down into exactly where that antibody is binding to achieve that effect.
Yeah, indeed, it'll quite often be the case. You simply don't know where it binds. It might be a linear epitope, it might be non-linear.
Yeah, I mean, if you do know, then that may help you get a broader claim, because you may then be able to get some kind of definition around that epitope. But if you don't know, I think you can still get a claim based on your particular antibody, as long as you can show an advantage.
Yeah, and trying to assert after the application's filed that it's routine to identify the relevant epitope is not a good place to be.
Yeah.
No, I think we've covered all the questions. And if there isn't more, then I perhaps will close the presentation. I'd just like to take this opportunity to really say thank you for everyone that's joined in. I hope you found this session useful. I would like to mention that you'll be redirected to a feedback form. We'd love to hear your thoughts about the webinar and what other topics you'd like us to cover in the future. Lastly, just to move on, next slide. Lastly, as you see, Hazel and Martin's email addresses on this slide. Please feel free to email them directly if you'd like to discuss anything that was mentioned today. And finally, we hope to see you at one of our future webinars. Thank you and take care.
Thanks, Abba. Thanks, everybody.